Good afternoon and welcome to the special meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Commissioner Keene.
Here.
Commissioner Rennie.
Here.
Commissioner Andrews.
Here.
We understand that Commissioner Han will be here momentarily. First item on the agenda is public comment on matters appearing or not appearing on the agenda that are within the jurisdiction of the Ethics Commission.
Good evening, gentlemen. Some of you know me. I'm Alan Grossman. Was the original petitioner in the litigation that is agendized as number 4. I have essentially 2 comments of a general nature. One is, over the years, as commissioners were appointed, served their terms, and moved on, Mr. St. Croix and his staff, which includes lawyers, handled almost all the routine, not so routine, activities for which the Commission was and is ultimately responsible. Those activities included enforcing non-complied with task force orders referred to it. Mr. St. Croix's hostility to open government is well known. He was, in fact, quoted in the New York Times. And he's particularly has the task force as one of his objects. So in that role, he has a record of dismissing or finding no violation in every task force referral of a public records matter, about 40 of them, 40 since 2005. In my 2009 lawsuit, he was forced to concede he had no legal basis to withhold records. The city ended paying my attorney's fees, some $25,000. The other point I think is really serious. You must be aware of the gravity of Mr. St. Croix's position in the litigation in Article Agenda 4. It is contrary to the Commission's own bylaws. Contrary to their own bylaws. It will empower city officials and other city personnel to seek help from the city attorney's office on how to dodge records requests or just ignore them, contrary to the specific requirement in the Sunshine Ordinance that the city attorney not act as legal counsel for any city employee or person having custody of a public record for purposes of denying access to the public. As a consequence, it will both discourage records requests and undermine the task force ability to adequately resolve these issues or to obtain compliance. Thank you.
Members of the Ethics Commission, Ray Hartz, Director, San Francisco Open Government. I'm going to affirm the words of the prior speaker, except I will change one to legitimize. I think the city attorney's office acts on a regular basis to encourage city employees to withhold records and tells them how to do it. The reason I base it on, I hold 17 orders of determination from the Sunshine Ordinance Task Force, one of which is an order of determination against Deputy City Attorney Paula Jessen, acting as the supervisor of records. After a year of trying to get Mr. Luis Herrera, the city librarian, to release public records, I petitioned her, and she denied the petition based on the fact that he was still producing them after a year. I waited another year. I petitioned her again, and she denied that petition based on the fact that he was still producing records, even though the law very clearly states the time limits and time frames that are allowable in responding to a public records request. Now, the city attorney in this case was found by the task force to have basically acted as a counsel for the city librarian. And my argument was, and they agreed with it, was the fact that if you simply sit back and don't do what you are required to do by the law, and you allow someone to withhold records for that length of time, actually you're participating or colluding in that effort. And since we now know that the Fair Political Practice Commission found that Luis Herrera had violated the law for 3 years by filing a statement of economic interest in which he, under penalty of perjury, claimed he had gotten nothing from a group called the Friends of the San Francisco Public Library, when each and every one of those years he had been getting $5,000 or more of trips and hotel accommodations and other benefits, all of which he knew, since he had been city librarian since 2006 and had repeatedly taken both ethics training and sunshine training, knew that he was required to report, and yet he'd lied. And the only reason that he was able to do so for so long was because the city attorney refused to do what the law says, which is get them to produce the documents, and if they won't produce the documents, refer it either to the city attorney or to the attorney general. So basically, if you're going to sit there as the city attorney and not do anything to help citizens get records when the law requires you to do that, that's the same thing as acting as counsel. No difference at all. Now, are you going to listen to any of this that's going to be said to you today? It is difficult to get a man to understand something when his salary depends on not understanding it. And I think some of you won't want to understand these things because your positions depend on it.
Good evening, Commissioners. Dr. Derek Kerr. In 2009, Mr. St. Croix had to concede that he had no basis for withholding documents from attorney Alan Grossman, and the city ended up paying $25,000 in attorney fees for that case. Now Mr. St. Croix has a similar position, and if it is sustained, it would contradict the Commission's own position regarding public access to public documents. According to your website, quote, the Commission provides open access to public records in ethics-related matters, unquote. It would also be contrary to your mission, which includes the quote, to practice and promote the highest standards of ethical behavior in government. Mission goes on to say that in order to accomplish it, the Commission shall actively enforce all ethics laws and rules, including campaign finance and open government laws. The Commission should question the unauthorized actions by Mr. St. Croix that he took in your name. Has he not usurped your statutory decision-making process and the Brown Act's requirements about public meetings? He defied the Sunshine Task Force and took it upon himself to defend Mr. Grossman's lawsuit twice. Then when he lost, he took an appeal by bringing it on his own. All of this could have been resolved if he had properly brought this matter to the Commission before there was any need for litigation. Thank you.
I'm Peter Warfield, Executive Director of Library Users Association, and we've had many complaints of a variety of complaints, including at least one that was included in Mr. Grossman's lawsuit, which he won, that concerned the Ethics Commission's not handling and not finding anything in the complainant's favor in well over a dozen cases at the Sunshine Task Force. Once again, and those were not taken up by the Commission, but rather determined by Mr. St. Croix without the Commission having a hearing. Now you're undertaking to do something similar where Mr. St. Croix is going to act on his own without Commission action taken. Your bylaws require you to comply with the Sunshine Ordinance, and should you decide to support Mr. St. Croix's claim that the Ethics Commission retains the privilege, you would in effect be violating your own bylaws. Amending your bylaws takes at least 2 properly noticed meetings and 10-day notice. In addition, it would be the beginning of a slippery slope to start carving out provisions of the Sunshine Ordinance that apply to the Ethics Commission, not just the one involving public access, but any San Francisco ethics code as well. This would be contrary to your mission and your reason for being. Thanks very much.
Hi, my name is Hope Johnson. I'm the former chair of the Sunshine Ordinance Task Force, so I have somewhat of a knowledgeable history of the interaction between the Ethics Commission and the task force. And I understand I'm referencing item 4 on your agenda. There is an issue related to the city attorney's office not following the carved out section of the attorney-client privilege in the Sunshine Ordinance. And I did just want to point out to the commissioners or remind you that in the Ethics Commission file number 08110-816 that you discussed on January 28th of 2013, the city attorney said that a whistleblower complaint, every single thing in it was attorney-client privilege and nothing could be seen. And we came before you and asked you to have the San Jose City Attorney's Office review that file. And indeed, they did find that it was overreaching. There were some records, not necessarily investigative records, but there were some records that should have been redacted and turned over. So I feel that the city attorney may be overreaching the attorney-client privilege once again. So I would ask you to look at that again to remind you that there are times when you have to assess how that attorney-client privilege applies under the law. And then I also just wanted to reemphasize that the Ethics Commission bylaws requires that the Ethics Commission comply with the Sunshine Ordinance. And because the Sunshine Ordinance is broadening access, that is why the attorney-client privilege section is in there, so that the city attorney and the deputy city attorneys can't give the city employees assistance in withholding public information or records. And if the public isn't able to evaluate that, then we can't see what kind of advice the city attorney is giving you on public records only and open meetings only. This isn't related to things that would actually be privileged. So if you were to find that privilege was being sectioned out by the Ethics Commission, that you didn't have to necessarily abide by the open meetings and the public records part of the attorney-client privilege, then you would be violating your own bylaws, as was mentioned before, which requires meetings that are not only San Francisco's laws, but under the California Public Records Act. Thank you.
Hello, my name is Michael Petrellis. I'm a gay blogger and a person with AIDS, and I'm wearing a button that says silence equals death. And that comes out of the horrible plague AIDS years of the 1980s. So, you know, the opposite of silence equals death is sunshine equals life. And we need a lot more sunshine in city government, and we need stronger enforcement of our sunshine laws from both the Sunshine Ordinance Task Force and this Ethics Commission. So, I'm a proud member of the Sunshine Group that is here today, and I'd like to call attention to the matter that's before you, Alan Grossman's lawsuit. And I want to state that since all the actions taken by Mr. St. Croix of the Ethics Department before and after the Sunshine Ordinance Task Force process and in the litigation were taken without the Commission first authorizing them by following the requirements of the Brown Act at properly agendized public meetings, whether in public or closed session, their legal effect even if the Court of Appeals decides in favor of the Commission, would be questionable at best. The Sunshine community would certainly pursue that course. All of that could have been avoided if Mr. St. Croix had submitted his proposal in the first place well before the lawsuit was started. This is really important, this matter, and I hope that you're going to give the proper attention and weight to what we are saying regarding Alan's lawsuit. We really need for you to do a better job of advocating for Sunshine, for the public that is filing these complaints and wants to have more sunshine in our government. I'm going to say it one last time. Sunshine equals life. We need more of it. Thank you.
Good afternoon, Commissioner Hur and Commissioners. I'm Patrick Manetshaw. The published description for today's agenda item 4 doesn't meet the requirements of the Sunshine Ordinance for a number of reasons, which, as you know, is grounds for filing a Sunshine complaint for deficient agenda items. The Commission is not the defendant in this lawsuit, as the agenda wrongly states. You are the petitioner, and your agenda is misleading. It's a material issue because you have not taken action to authorize this suit in your name, and yet you're calling yourself defendants. Doing so, you're obscuring this important contradiction. The agenda also appears to violate Sunshine Section 67.11, which states, quote, prior to any closed session, a policy body shall state the general reason or reasons for the closed session, and in the closed session, the policy body may consider only those matters covered in its statement. Today's agenda hasn't done that adequately by failing to mention two basic matters. First is this, first, in the two-sided lawsuits regarding the invalidation of a key section of the Sunshine Ordinance that removes the attorney-client privilege regarding access to public records. That is a major omission. The other is the issue of compliance with the Brown Act. Commissioner Keene. Commissioner, did any of you receive records from Mr. St. Croix prior to today's meeting? Because if you did, you have to make them available to the public. And you have to make them available prior to the meeting.
The next.
Good evening, David Pilpel, also a former chair of the Sunshine Ordinance Task Force, but you probably don't want to confuse me with the other people here because they probably don't want to be associated with me. I wanted to make a couple of comments on agenda items because I was not planning to stay after the closed session. With regard to the draft minutes, I provided staff with some suggested edits that I hope improve the readability without changing the substance of what happened last month. And with regard to future meetings and agenda items, I would suggest that the amendments to the lobbyist ordinance that are being considered by the board be reviewed with the commission either at the next meeting or the one after that. And then, as I indicated last month, depending on how the next referral from the task force regarding records at the planning department goes, it may be time to review again the procedures for handling referrals from the task force. I've had some discussions with staff about that, and I hope that they've been productive. And then finally, in the event that the civil grand jury issues another report on the commission, which it might do, we should probably set aside time for that, either at the July or August meeting. Thanks very much. I do intend to comment on item 3. Thanks.
Next item on the agenda is discussion and possible action regarding McCutcheon versus FEC. St. Croix, do you want to introduce this matter?
Okay. As the memo points out, and everyone undoubtedly knows, this particular decision would appear to have an impact not only on federal law, but on the several states and localities that had similar prohibitions, or limitations, I should say. We believe that we have no choice, however unfortunate the ruling is, to follow compliance with that. At some point, we're going to probably need to alter what's on the books in San Francisco. We don't think that that is necessarily something we have to do right away. We could fold it into some other changes that we have planned for the coming 6 months, 6 to 9 months. But we do think that the Commission should consider adopting a policy much like the City of Los Angeles has done, basically stating for the record that this is not an area we can enforce based on the Supreme Court ruling, so that we can inform candidates in upcoming races that this particular restriction does not apply, again, based on the Supreme Court ruling.
Comments from the commissioners? Commissioner Keene.
I agree with Mr. St. Croix that McCutcheon makes it unconstitutional for there to be any kind of enforcement of an aggregate limit. So it's something that, as a reality, no jurisdiction could carry out, even though we still have it on the books. So even if we didn't adopt the resolution of non-enforcement, we couldn't enforce it anyway because of the court's case. I guess in order to give notice to any candidates who might be relying upon the present state of the law, saying that they can't aggregate monies in regard to running, it's unfair to them for us not to give them as much notice as possible on this local level. So I support the idea of adopting a resolution of non-enforcement.
Other comments from the commissioners?
Take it, though, that it's not going to affect the maximum that can be contributed to each candidate.
No.
That should be made clear.
Very good.
I agree with that sentiment that we should adopt the resolution. I don't see how we can enforce it in any event, as Commissioner Keene has stated. Any comments from the commissioners on whether the staff should just deal with this on a one-off basis or prepare other changes to the CFRO and for us to consider as a package?
I did want to hear a little bit more from Mr. St. Croix. And I wrote here how many more changes. You said over the next 6 to 9 months that you'd be looking at a couple other changes.
Yeah.
And they seem and those are inevitable, right?
Yeah, I mean, we do have the CFRO is something that we have to work on a fairly regular basis. So.
I'm in agreement with Commissioner Keene that the more notice that we can give candidates, the better. So I would support moving forward with decision 1.1 and just hold off on actually having a full resolution to remove it, but just non-enforcement.
On the point about whether the staff should work up whatever multiple changes to CFRO they have, do you think we should wait for that, or should we?
I don't see a reason why we. It just seems like it would be extra work when we can't enforce it. It would be extra work on inevitable work that's ultimately going to happen within the next 6 to 9 months. So I would rather give them the opportunity to make all of the changes at once and just move for a resolution for just non-enforcement now, and have them wait over the next 6 to 9 months.
Other comments from the commissioners? What Commissioner Andrews said sounds quite sensible to me as well. Public comment on item number 3.
Members of the Ethics Commission, Ray Hartz, Director, San Francisco Open Government, and I'm going to make the same comments I typically make when you take up CFRO items. It's like rearranging deck chairs on the Titanic. This city is such an unethical morass, and basically you spend 90% of your time rearranging these rules about campaign finance. And when you talk about ethical things, we can't come to you with an ethical thing like the city librarian accepting thousands of dollars worth of gifts from an entity he's supposed to be overseeing and then lying on a statement of economic interest under penalty of perjury that he got nothing. We had to take it to the FPPC because you wouldn't have handled it. You would have just ignored it. And I'll ask you the same question I've asked the Sunshine Ordinance Task Force. Would you rather serve on this board for a single term and leave knowing that you had actually made a difference in the ethical scheme of this city? Or would you like to just sit here and be bumps on the log who sit here and rearrange the deck chair? You know, basically these CFRO issues are nothing but confusing accomplishment with activity, or activity for accomplishment. You're very active. Yeah, you do a lot of things and you change the law around, but when it comes down to things like enforcing these laws, when do you ever do it? What city agency or city department head or anything has ever been found in violation of any of these laws? And whenever they quit and they go to work for some group that they've been working with for the last 5 years in their city-paid job, and then they come and ask you for a waiver so they can go and then work for those people, you go, oh, sure, no problem, just go work for them. And we'll ignore the fact that you probably arranged to give them a nice big fat contract before you left, and now you're going to go over there and you're going to take a lot of proprietary information about how your department or your agency deals with these things, what they look for, what they don't like, and give it to them so that they can get a heads up over all the competition in getting the city largesse. The bottom line is, I watch these ethics commissions on television, and you know I come here very often. And I'm still really put out of joint that you want to sit here and act like you're a fair body when what you did to me was take a hearing that was referred over by Sunshine and schedule it on the day after I left the state and heard it on the day before I got back. And I really did expect that one or two of you would have some integrity and ask that that be brought back on the schedule instead of sitting there and simply saying, oh, what a coincidence that the city librarian got off the hook in this violation because we scheduled it while Mr. Hartz was out of the town. And you really want people to think that was some sort of a coincidence. And Mr. St. Croix's disingenuous, I was really surprised that Mr. Hartz didn't show up at his own hearing. No, he wasn't surprised. He knew I was out of town, and he scheduled it that way purposefully. And anybody who believes that otherwise is a fool.
Good evening, Commissioners. I'm Anita Mayo from the law firm of Pillsbury, Winthrop, Shaw, Pittman. I would like to make a few comments in support of staff's recommendations to, 1, adopt a resolution of non-enforcement of the aggregate contribution limit, and 2, repeal the aggregate contribution limit. As you know, the recommendations by staff are based on the recent U.S. Supreme Court case, McCutcheon v. Federal Election Commission, issued April 2nd of this year. As a First Amendment case, McCutcheon addresses the right of citizens to participate in electing our political leaders. Contributing to a candidate's campaign is one of the ways a citizen can exercise that right. The court stated the following regarding this right. 1, there is no right more basic in our democracy than the right to participate in electing our political leaders. 2, the right to participate in democracy through political contributions is protected by the First Amendment, but that right is not absolute. 3, Congress, or a state or local government, may regulate campaign contributions to protect against corruption or the appearance of corruption, but it may not regulate contributions simply to reduce the amount of money in politics or to restrict the political participation of some in order to enhance the relative influence of others. In other words, leveling the playing field is not permissible. 4, money in politics may at times seem repugnant to some, but so too does much of what the First Amendment vigorously protects. And 5, the First Amendment has its fullest and most urgent application precisely to the conduct of campaigns for political office. It guards an individual's right to participate in the public debate through political expression and political association, and both of these rights are involved when making contributions to a candidate. Using these principles as a backdrop, the court invalidated a contribution scheme of base and aggregate limits similar to the contribution scheme included in San Francisco's campaign law. The court stated that aggregate limits prohibit an individual from fully contributing to the primary and general election campaigns of candidates, even when all contributions fall within the base limits. Once the aggregate limit is reached, it serves as an outright ban on further contributions to any other candidate. The aggregate limit thus denies the individual all ability to exercise the donor's expressive and associational rights by contributing to someone else who will advocate for the donor's policy preferences. Based on the foregoing, I urge acceptance of the recommendations by staff. Thank you.
Ms. Mayo, I imagine you feel vindicated by this. I remember you pushing for this many years ago.
Many years ago, when it was first adopted. Yes. Thank you.
David Pilpel again. I agree with Ms. Mayo that the Commission should adopt Decision Point 1 and not enforce the provision, and should hold actually a series of interested persons meetings, probably one or two initially, spend some time reviewing options, and then come back for another series of interested persons meetings prior to bringing a package before the Commission, hopefully towards the end of this year, that would take effect next year. I've never been a fan of this particular aggregate contribution limits. It's always seemed odd to me that it would be based on the number of offices being elected rather than anything else. It really has only been at play in San Francisco, in my opinion, in years when there were multiple open seats or contested elections on the Board of Supervisors, and it wasn't clear who the front runner was, and a contributor might have wanted to contribute to several different candidates, but was limited by $500 times the number of candidates on the number of offices at issue. So, in summary, I think it's fine to not enforce, and I would look forward to interested persons meetings. There really was an overall scheme to CFRO with contribution limits, aggregate spending, various other provisions, and they sort of work together to create the ordinance as a whole. So if this particular piece is being taken away, I think we need to look at other pieces and how they might play out, both to potentially increase and other ways that we might decrease the amount of contributions and spending in local campaigns. Thanks.
Hello, Michael Petrellis again. I'm reading your document here, and in the introduction it says, in short, staff recommends that the Commission resolve to suspend enforcement. I got to repeat that. You're asking, you've been asked by the staff to suspend enforcement. I can't really read beyond this and take it seriously, or to try and take this Commission seriously. This is summing up the problem, I feel, with so much of what you don't do. You're not a watchdog. I saw the hearing on television a few months ago about the woman who had from the Public Utilities Commission, who had been found to violate twice. She admitted guilt to 2 violations. And instead of taking the right course and enforcing some penalty against her, you dropped the matter. Okay? Recently, I filed a number of complaints about public officials who were not filing the proper paperwork before they were traveling out of town. It took a number of months, I'd say a good 6-7 months, to get a reply from the Ethics Commission saying that, yes, these people had not followed the law in terms of disclosing their trips out of town, who was paying for them, and making the disclosure before they took their trips. Again, basically no enforcement, no penalty. That is why so many people in the public are not filing complaints. Do not come here to ask you for help in getting more sunshine and bringing more ethics, because you've created such a bureaucracy, it's difficult to get through. And then when we read your documents and it says you want to resolve to suspend enforcement of anything, it is really sending a message that it is not this is not a public watchdog. You've got to pay attention to the fact that the public is growing frustrated with this commission, with the Sunshine Ordinance Task Force, and how enforcement and penalties do not seem to ever be applied against the city departments. Thank you.
Patrick Manette, I'd like to echo what Mr. Petrolis just testified to. This body has been an absolute failure at enforcement of Sunshine Orders of Determination referrals to this body. And you have repeatedly dismissed or found reasons to let city officials off the hook unfairly. Now you want to suspend enforcement of campaign finance regulations. If you're going to continue abdicating your enforcement obligations, why don't you have City Attorney Dennis Herrera wave that magic wand of his and simply disband this body, because you're obviously not doing enforcement.
Yes, Peter Warfield again. Excuse my voice. This is not an item that I particularly came for, but I'm very disappointed, to put it mildly, that I don't believe that the agenda item gives a clue to an ordinary person, as required by Sunshine, whether their interests would be affected. I'd be happy if somebody would quote from the Sunshine Ordinance exactly what's required with respect to the explanation that's given in an agenda item. But on this agenda item, discussion and possible action on the Ethics Commission's policy response to the United States Supreme Court's decision in McCutcheon versus Federal Election Commission, number so on and so forth, period. They would certainly have to read the attachment, and before they read the attachment, they probably would have to be familiar with that decision, and might well not be. However, they certainly might be a campaign contributor or somebody who's running for office or somebody who's interested in that. There's nothing in here that states what the plain intention here is, which is concerning aggregate campaign contributions limits, concerning the city's campaign finance reform ordinance, concerning something additional to McCutcheon, because McCutcheon, you note in your first paragraph of the legal background, struck down a federal law which found that a federal aggregate limit violated the First Amendment. And now you're talking about something that affects city law and local elections. So I think that your agenda is very, very sadly lacking in the minimum requirements for folks to understand what it is that you are thinking about doing or planning to do. And I don't think it's that hard, because I think it has been stated fairly succinctly in the memo that you have received, and that succinct summary should be at least something that you state is something you're planning to consider within the scope of this agenda item. Thank you.
Is there a motion to adopt the attached resolution and to direct staff to include a provision repealing Section 1.14A2 in a planned package for future amendments to CFRO?
So moved.
Is there a
Second.
All in favor? Aye. Opposed? Hearing none, the motion passes 5-0. The next item is discussion and possible action on the pending litigation, Grossman versus John St. Croix, Executive Director. We just made them into one decision point. The next item on the agenda is relating to Grossman versus St. Croix and the Ethics Commission. Public comment on agenda item 4, including whether to meet in closed session.
Since this is the first public hearing on these two cases, I have no way of knowing how much you know about them unless you were given information of either by Mr. St. Croix or by the city attorney. I wouldn't touch right now the issue of asking for the material provided by the city attorney, but I do think that any material you got from Mr. St. Croix must have been available to the public when this notice and agenda were published, and that's right in the law. On the assumption you know something about it, I'll go ahead. The attorney-client privilege belongs to the client. That's you. It doesn't belong to Mr. St. Croix. There are 24 public records that he refused ultimately to disclose. 4 were disclosed once we filed the lawsuit. At the task force hearings, he said, when asked, can you describe the records? Mr. St. Croix said, I haven't read the records, I haven't looked at them, and I haven't counted them. Okay? So he usurped your job because you were the ones that should have been looking at those records and deciding whether or not to waive the privilege, even assuming you had it. I could go through this whole list of occasions when this matter could have been brought to you. There are at least 7. When the task force acted on my complaint, when it found Mr. St. Croix responsible to disclose them, when he didn't and the compliance committee said it should be referred to you, when the reference was made, there are probably 2 or 3 others. So all this time, you could have been dealing with a situation which could have been resolved the day after I asked for the records. So let's put it this way. There's no time machine that's going to bring you back there. It isn't going to happen. So this is where we are. We're at a place where the case was heard by the Superior Court judge, and he found that the records were disclosable. Mr. St. Croix, not the commission, appealed that and filed a mandamus case. Briefs were filed, an oral argument was heard, and we're now waiting for the decision. And we don't know what it's going to be. So what is there going to be to discuss and confer with the city attorney about? Thank you.
Dr. Derek Kerr again. Regarding the closed session issue, the Sunshine Ordinance, Section 67.10, provides that a policy body may, but is not required, to hold closed sessions. It cites three requirements: has to be based on the advice of legal counsel, and a motion and vote in open session to assert the attorney-client privilege, and three, when discussion in open session would likely and unavoidably prejudice the position of the city. How would discussion in open session unavoidably prejudice the position of the city? Because both cases are practically over. The real question is whether the Commission will support the Director's position. But isn't that what public comments should address? And isn't that something that the Commissioners should speak to in open session? And shouldn't the advice from the City Attorney be in writing? And if so, where is it? Another reason why openly discussed draft reviews by the Council should be preferred is because such drafts are commonly reviewed openly at board meetings, board committee meetings, and even the Planning Commission. Draft legislation is openly discussed in other settings, so why is it different here? Sunshine. Thank you.
Patrick Manetshaw. On my website, stoplhdownsize.com, I posted my article, Sandbagging, Legal Fairy Dust, and Doublespeak in March. Sunshine Ordinance 6712A2 does not say that a policy body can delegate to a staff member decision-making to pursue litigation which the policy body is required to report out from closed session in an open session. St. Croix does not hold closed session authority under his own right. 6712A2 suggests that decisions to enter into litigation must, at minimum, be determined by this policy body, not by its executive director. And you're required to do so only during a properly noticed open or closed session meeting of the body. Since the Commission never authorized the lawsuit, small wonder Michael Ng asserted the court should deny Shen's appeal outright. Shen argues this doesn't make the case procedurally defective, but of course it does. It's a big deal because not only was Shen's request to strike down 6724B1 Roman 3 not properly brought before the Superior Court, Shen's appeal on behalf of St. Croix was also not properly brought before the Appeals Court either, due to the Commission's failure to authorize the appeal. Shen's appeal indicates it was filed in the name of St. Croix and the Ethics Commission, but you didn't actually bring it. It's a bigger deal still that St. Croix lists on his Superior Court and Appellate Court filings the 5 city attorneys are representing him. 6721I prohibits the city attorney's advice from acting as legal counsel for purposes of denying access to public records. But here we have the city attorney representing St. Croix at both trial court and appellate court. The ordinance also provides that the city attorney cannot give confidential advice to city officers regarding ethics and public records. But that appears to be precisely what Dennis Herrera is doing. The Ethics Commission should have obtained independent legal counsel to represent St. Croix rather than turning to the city attorney, who theoretically is prohibited from doing so. This may be yet more of City Attorney Dennis Herrera's fairy dust.
Get this up on the screen? Oh, okay. One of my favorite authors, Frank Herbert, wrote, "Politics is the art of appearing candid and completely open while concealing as much as possible." Members of the Ethics Commission, you have really almost completely descended into political theater. The Sunshine Ordinance says when you agendize an item, it's supposed to give enough information that a person of reasonable intelligence can read it and understand whether or not their interests would be affected. And I can read this thing, and I can't tell what the hell you're going to discuss. As has been discussed by prior speakers, I have to wonder what you are going to discuss, because apparently, since you have provided us no documents, you got no documents. So you're going to go into the room and you're going to have a substantive discussion on what? The air. You have no documents to look at. And it's all going to be attorney-client privilege, which is really, really kind of a broad brush. Anything you don't want discussed out in front of the public, you put under attorney-client privilege, and then someone says, well, prove it is attorney-client privilege, like Mr. Grossman has done, and you can't do it. And you come back from these hearings, and you have a discussion about whether you should disclose anything, and you never do. And I have a hard time believing you go in there for a half an hour, 45 minutes, whatever it happens to be, and have these long, drawn-out discussions and never talk about anything that you should disclose. What I'm really saying is the citizens of San Francisco want open government. That's what they voted for 3-1 when they passed the Sunshine Ordinance. And they did that to reinforce and bolster the Brown Act and the California Public Records Act because they didn't feel they were enough for the city of San Francisco. So how any of you could sit there and really take any position other than the fact that being open with the public is something the public expects, I just can't fathom. And yet you will do it continually. You will go into a back room, you will have discussions about something. We don't know what you're discussing. We don't see any documents that you're discussing. We don't see any of these nothing to actually say, here's what we're going to go back and discuss. Just a vague statement that nobody would have any idea, well, it's Mr. Grossman's case. What about Mr. Grossman's case? And the public has a right to know these things. And I'll bring one last thing up. I, as I said, have 17 orders of determination for the Sunshine Ordinance Task Force, 7 of which have been referred to this body, and every single one has been dismissed by your staff saying the Sunshine Task Force got it wrong. You're right every time, and they're wrong every time. And the citizens of San Francisco shouldn't have to haul you into court to get you to be open and honest.
Hello, Michael Petrellis again. I'd like to encourage you to not take this matter behind closed doors. There is far too much darkness regarding city government, and it would do no one any good for you to take this matter behind closed doors when you haven't presented us with documents about what you're going to discuss. And when you come out from your closed session, we're not going to have minutes. We're really not going to have a substantive sense of what you've discussed. One thing I want to address that I've learned from reading this new book, Forcing the Spring, about the Prop 8 lawsuit and gay marriage. The author, Jo Becker from the New York Times, writes in her book that she was given access to documents that went back and forth between the city attorney of San Francisco and Ted Olson's office. Okay? Also, this New York Times reporter was allowed to sit in on discussions the city attorney was holding about their arguments that they were going to be making to Judge Vaughn Walker and then before the Supreme Court. You read this book and you wonder, how the heck did Dennis Herrera allow this New York Times reporter to see documents, including the email exchanges between Herrera's office and Ted Olson's office, and she was sitting in on their discussions about the arguments, the legal arguments they were going to make. And now she's taken that access that she had, she's written a book, and she's, publicizing that book and making a profit from it. She's making a profit from the access that she gained to city government. If any of us, just regular taxpayers here in the city, wanted the same access to those emails or to the sit in on the discussions, we wouldn't be allowed to do that. But Herrera has made a serious ethics lapse by allowing that reporter to have all that access for a commercial reason. All of this is adding up to more and more distrust of this commission by the public to serve as a watchdog. We don't really see you as watchdogs. We see you as lapdogs, and that is not good for our local government. Please do not take this matter behind closed doors.
Good afternoon, Commissioners. I hope you remember that I brought this lawsuit to your attention back on September 23rd. At that time, there was a full 2.5 weeks for you to step in as one of the named respondents and take responsibility for this lawsuit. Apparently, you didn't do so. I wonder if you have a policy that you categorically ignore things that are brought in front of you from people who are not of your class. I don't know what you think your class is, but in fact, we've decided as a society that having representation for the entire citizenry and have representatives who will hear the points we want to make is one of the things that holds society together, and the society needs to include everyone. Now, if you look at your own agenda, it says that you're going into closed session as defendants. Of course, this is preposterous. There are no defendants in this lawsuit. You are the petitioners to the extent that you're a party at all. That raises a number of significant issues. First of all, you can't be petitioners without taking action to initiate a lawsuit. When did you take action to initiate this lawsuit? I've been following this commission closely. I don't think you've done so. In fact, if you've not taken action to initiate this lawsuit as petitioners, you're not parties at all. If you look at the provision for going into closed session, you will find that one of the provisions for going into closed session is to discuss with your attorney as a party to the litigation. All of this would have been much more clear if you had put in the dates in the agenda of the times when this lawsuit was filed. It's true that you were respondents in the lower court and you are petitioners in the upper court now. But of course, the fact that you've not included those dates is another flaw in your notice. Why is it that we always appear before you to find out why you're frustrating ethics rather than implementing it? The idea that you're the ethics commissioners is supposed to be your purpose, not just your title. And in fact, enhancing ethics is what this should have been about. Many issues. Thank you very much.
Peter Warfield again. The Sunshine Ordinance Task Force and pretty much ethics are basically supposed to be about openness. And yet, this is all about secrecy, keeping documents secret. The civil grand jury said this was a sleeping watchdog. I think they got it a little wrong. The watchdog is awake, but is guarding the secrecy and not the public's interest and openness. Since all the actions taken by Mr. St. Croix before and after the Sunshine Task Force process and in the litigation were taken without this commission first authorizing his actions, following the requirements of the Brown Act and Sunshine, in properly agendized meetings, whether in open or closed session, the legal effect, even if the Court of Appeals decides in favor of the commission, would be questionable at best. The Sunshine community would certainly pursue that matter. And all of this could have been avoided if Mr. St. Croix had submitted his proposal in the first place well before the lawsuit was started. At the very least, I would ask you to discuss this matter openly and not go into closed session. Thank you.
Good evening, Commissioners. My name is Hulda Garfulo, and 3 years ago, I served on a civil grand jury committee that reported on this body. Unfortunately, it's very alarming. Some of the players have changed, but the game remains the same. We were very concerned that this body, which was supposed to be the top regulatory agency in the city, had abdicated its authority to its executive director. It's alarming to see nothing has changed. I would hope that you would do your due diligence. Our committee reported that your performance as an ethics commission body was underwhelming, and it seems nothing has changed. Thank you.
Good evening again, Commissioners. Hope Johnson. I also want to emphasize that if materials were distributed to you for the closed session, that they would not be privileged, because this is about the closed session you're going into is related to public access laws and the Sunshine Ordinance. So again, they would fall under that same section of the Sunshine Ordinance that makes the public access not attorney-client privilege. So I don't know if you had any materials distributed to you or not, but it's something that we should have access to. And along that same vein, the court action itself is about the ethics regulations for handling Sunshine referrals and complaints. And pretty much the Ethics Commission's entire process about that has been somewhat closed. During my time on the task force, we tried to work with you. We were grateful that you asked for our opinion, and it took us a long time to get back to you. But a lot of that was because we had to do every single thing in open session. And in fact, our deputy city attorney that's assigned to us that's supposed to have an ethical wall between them informed myself and the vice chair that it would be a conflict of interest for him to help us with these. So we had no access to what the city attorney was thinking. We had no opinion offered to us from the city attorney. Our own attorney that's appointed to the board did not wish to participate. So indeed, Mr. Grossman did help us, although the city attorney was rudely referring to him as a ghostwriter. He wasn't a ghostwriter. It was a collaborative effort, just like the Board of Supervisors does. And we did it all in open. We did it all in front of the public, and we had it all agendized. We had everything attached. And again, this is about the Ethics Commission's process for how they're going to handle the Sunshine Ordinance and public complaints. And we have no idea what that process is. We don't even know exactly what it is that you're going to have a discussion about. So it's something that we feel like you're hiding behind the attorney-client privilege, that the process that the Ethics Commission would even go through and consider how to handle those things. This is part of why, we're concerned. It's part of the reason why Mr. Grossman wanted to see what it is that was exchanged. How would the Sunshine Ordinance Task Force work with the Ethics Commission if we don't even have any kind of information about the thought process or the deliberation? Thank you.
Comments from the commissioners on,
I'm sorry, can I just interject quickly?
okay.
I think that there were certain non-privileged documents that were distributed to the commissioners that were not made attachments to the agenda. And there is a requirement under the Sunshine Ordinance that all documents distributed to commissioners, so long as they're not privileged, have to be attached and made available to the public. It sounds like that didn't happen, so I would recommend putting this over to the next meeting.
Okay. And staff, do you have any view or opinion on that? I mean, what happened here?
I wouldn't want to contradict that recommendation,
What does that mean?
that the city attorney made. Normally, when we have closed sessions, the documents related to those, normally when we have closed sessions, the documents related to closed sessions are not included in the public packet.
Commissioner Rennie?
I see no reason why we don't give them a list of what we received as a package. They are essentially just court papers. And there's no reason why to keep it a secret or keep people thinking we got something that they didn't see, couldn't have seen.
I think
Commissioner Keene?
Yeah, I agree with that. In regard to the comments from the public as to what we got, and some of the comments have the assumption that, well, we got this material, and we're going to look at the material in closed session. Well, we haven't voted as to whether or not there's going to be a closed session yet. We have a public item on item 4, talking that we're going to discuss the Grossman case, and then it talks about a possible closed session. Maybe there'll be a closed session. I can tell you right now, I'm going to vote against any closed session. I think the whole thing should be done in open session tonight. All of this stuff should. So in regard to that, having to do with the materials, whether there's any kind of secret relating to the materials, when this came up the last time, I was one of the ones who said, well, I'd like to hear a total discussion about this case. I knew the case was pending before the Court of Appeal. And I wasn't on the commission when that happened. I'd like to be brought up to date on the history of it. And one of the things that I did is I asked Mr. St. Croix to send me all of the briefs from the Court of Appeal, the briefs on behalf of the petitioners and the briefs on behalf of the respondents, which is a pretty good statement of all of the legal issues and all of the legal arguments and all of the background regarding this issue. So I've made myself pretty conversant with everything that's involved here, and I'm prepared to talk about it tonight, and I'd like to talk about it tonight. So in regard to one of the members of the public's specific request to me, what did you get? That's what I got. I could have gone to the Court of Appeal myself and gotten these materials. Instead, I took the lazy man's way as sort of the prerogative of a commissioner and asked the executive director to send me the briefs. Those are the materials I have. All of them are public. All of them are very informative, well argued by good lawyers, and they present some interesting issues. And I'd like to talk about them tonight.
I would just, thank you. I would just make the quick point that 67.9 of the Sunshine Ordinance doesn't simply just require a list of documents. It requires that any documents, any non-privileged documents that were distributed to the Commission should be posted on the website and, made available to the public in the same manner as the agenda. So I hear what Commissioner Keene is saying, and even though, even though the bulk of the documents that were distributed were public documents, I don't think that it's sufficient under the Sunshine Ordinance that they just be publicly available somewhere. I think they actually have to be attached to the agenda. And since they weren't here, I think my recommendation would be to just put this matter over till next month and make these documents, make the non-privileged documents available in the same manner as attachments typically are. So that would be my recommendation.
Okay, so Commissioners, I'm inclined, based on the advice of the city attorney, to put the matter over. I mean, I don't see how, if the city attorney is telling us that there are documents that should have been included in the packet that were not, I think we're opening ourselves up to another sunshine issue by not providing the documents to the public per the city attorney's recommendation. Is there some vote that we have to take to do that? Okay. Is there an objection from the commission?
I object, yes.
Because you disagree that it would be a violation of the Sunshine Ordinance to not provide them?
I do, and in the sense of sort of no harm, no foul. What we're doing, I think Commissioner Rennie's suggestion relating to the fact that we just inventory what we have, and in regard to the materials that I've seen that everybody has gotten, there's nothing that's of any particular moment or any great importance that somehow we've substantively violated the spirit of the Sunshine Ordinance. All of the people here and the public will know what it is that we're taking up. The fact that we referenced that we are going to be discussing Grossman versus St. Croix, which is before the California Court of Appeal, First Appellate District, case number A140308, in my opinion, incorporates by reference all of the matters that would be there before the Court of Appeal. Those are the only materials that we have. I think we have advised the public as to what materials we're working for under when we tell them that that's what we're discussing and we reference the particular case before the Court of Appeal. There's nothing else that we have that's secret or that we're sandbagging the public on in any way. I think that's sufficient notice. I think we've gone ahead. We started the discussion. The discussion has started in a good, healthy, robust way. We shouldn't abort it at this point.
Through the chair, a short point of order, please.
No, Mr. Shaw.
You have not notified the public that you were going to have a...
Mr. Shaw? Commissioner Keene, I think my concern here is the same way that you got the materials, that we got the materials, was provided to us directly. I mean, I don't think you can necessarily expect the public to go and review all the pleadings that we received without having them included in the packet, if it's the opinion of the city attorney that it needed to be included. Did any other commissioner want to comment on this matter?
I just only heard the word the bulk of. The city attorney said the bulk of. The city attorney said the bulk of the information was shared. You didn't say all of it.
There's one document that is protected by the attorney-client privilege that would not be posted. Yeah.
Any other commissioner want to weigh in on this issue? Okay, let's put this over to next month. By the way, it would have been nice to know this before we got to the
Ask your staff.
The item. I mean, really.
I apologize for that, and I apologize for that.
Isn't there public comment on the motion to put it over?
There was no motion to put it over. It's a
ruling of the chair.
Scheduling issue.
Okay, thank you.
Okay. The next item on the agenda is discussion and possible action regarding a complaint received or initiated by the Ethics Commission and possible closed session. Public comment relating to agenda item 5, including whether to meet in closed session.
Commissioners Rehart, Inspector San Francisco Open Government, and I've done this on numerous occasions, you know that, and you're tired of hearing it, and I'm tired of saying it, but since you don't listen, it has to be repeated. And I think, I can't remember the exact quote, but Barry Goldwater says that, if you're hesitant in the defense of liberty, it's not a virtue. The bottom line is these closed sessions are really, all the time, they appear that you're hiding stuff. It's very well and good to argue, well, we have a bunch of documents, they're all legal documents, and they're all related to the case, and the public should somehow figure out which one of these documents we're specifically discussing in this closed session. I would imagine this legal case has hundreds of documents. Are you going to look at, and did you get hundreds of documents, or did you get 30 pages or 50 pages, and what specific documents do you get in these matters? And I would be willing to bet that in this particular case, it's the exact same thing. You've been given documents that the public hasn't seen, and we're supposed to guess. What we used to call in the Navy a wild, hairy-ass guess. What you're talking about in those closed sessions. Because you don't tell us anything. You say, we're going in a closed session, we're going to discuss X. What about X? And I think when we look at what actually just happened in the last case, I think there's a good argument for that. The city attorney comes out and says the bulk of what we had should have been disclosed. And you all sit there and act like it's the city attorney's fault. It's not. It's your staff. Your staff is the one who makes the agenda. Your staff is the one who sends you the materials. They're the ones who pick and choose what you look at and what you don't see. And the public deserves the same right to know what it is you're going to go in there and discuss, because for us to make comments relating to whether or not it should be an open or a closed session, we have to know what it is you intend to discuss in a closed session. We can't just guess. We shouldn't be put in that position. It's not equitable. It's not reasonable. It's certainly not open and honest. As I said in the Frank Herbert quote, it's all well and good to appear open and honest, but if the bottom line is none of us can figure it out, and the Sunshine Ordinance specifically says the agenda should contain sufficient description of the item so that a person of reasonable intelligence can understand whether or not their interests would be affected. And your staff does not do that. And this is not just a one-time case, it's all the time. They put in just the bare minimum where they say, oh, well, we can go in and we can argue that we technically met the law. But the intent is we're supposed to be participants whenever possible. And you can't be a participant without the documents. It's why we have the California Public Records Act. It's why we have the Sunshine Ordinance. You can't make reasonable public comment if you don't have the public records you need to do so effectively.
Is there a motion to go into closed session regarding agenda item 5?
I so move.
Is there a second? I second. All in favor?
Aye.
Aye. All opposed?
No.
Commissioner Hand was in favor? Okay. The motion passes 3-2.
Of course, the holdovers.
We will now move into closed session.
And that's where you have it all confused.
big dreams and good grades aren't enough to get into college. There are actual steps you need to take. Finding someone who can help is the first and most important. For the next steps, go to knowhowtogo.org.
Good morning and welcome to the San Francisco Fire Department Division of Training. I am Assistant Deputy Chief Ramona Williams, and I'd like to welcome you and thank you for coming to honor these graduates of the 116th Recruit Academy. Ladies and gentlemen, I'd like to present to you the 116th H2 Firefighter Recruit Class. Recruits, please be seated. At this time, I'd like to have Father John Green come forward and lead us in an invocation.
Good morning, everyone. They made it. Let's give them another. Well, congratulations not only to our new graduates, but to all of you, family and friends, who helped them through this time. I know they're very appreciative of that. We're very proud of this new class, and we want to wish them all the best as they begin their career as firefighters, as they serve our city, and as they share in so many ways in the protection and safety of all of our citizens. We come from many different traditions, and yet we just gather in our good thoughts and prayers for this new class and for ourselves. Lord our God, we thank you for our new firefighters. We ask you to watch over them, help them to learn this job, help them to always be proud of this job, and to always have a sense of how great a gift it is to be a San Francisco firefighter. Bless their family and friends and all of us here today. Amen.
At this time, I'd like to introduce Captain Nikki Griffey, who will lead us in the Pledge of Allegiance, and if you would all now stand. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Have a seat. And now I'd like to introduce and honor our honored guests. On my left, we have the Honorable Mayor Ed Lee. We have Supervisor Scott Wiener. We have Father John Green of St. Robert's Church. We have Deputy Director of the DEC, Robert Smuts. We have Assistant to the Executive Director of DEM, David Erbalal. And he may not be seated, but we have the Vice President of Education and Outreach at the San Francisco Fire Credit Union, Glenn Gortney. We have the President of the Fire Commission, Steve McCutcheon. Vice President of the Fire Commission, Andrea Evans. And we have fellow Fire Commissioners, Ken Cleveland, Francie Covington, and Michael Hardiman. We have Fire Chief of Department, Joanne Hayes-White, Deputy Chief of Operations, Mark Gonzalez, Deputy Chief of Administration, Raymond Guzman. We have Assistant Deputy Chief of Support Services, Ken Lombardi. Assistant Deputy Chief Fire Marshal, Michi Wong. We have Assistant Deputy Chief of the Airport Division, Dale Carnes. We have the President of the Chiefs Association, Battalion Chief Brian Rubenstein. We have Dr. Ye, in charge of medical. Did I forget anyone there? We also have in the audience the President of 798 Local Union, Jim O'Connor. We also have numerous board members in the audience, Sean Buford and Floyd Rollins. To my right, we have our training staff. We have Captain Nikki Griffey, Lieutenants Bob Arazavi, Lieutenant Justin Brown, Lieutenant John Kaba, Lieutenant Norm Kaba, Ernest Carrillo, Arnold Choi, Jay Draper, James Cotter, Julie Mao, George Smith, and Tyson Yee, who's not here today. Under EMS staff, we have Section Chief Melanie Brandon, Paramedic Captain Jim Perry, Paramedic Captain Clem Avila. Under Special Projects, we have Captain Ed Moy. In-service training staff, our TI training facility, we have Captain Jeff Colombini, Lieutenant James Melberg, Lieutenant James Reedy, and Lieutenant Pat Shea. Also in attendance, my administrative staff, which consists of Rose Felix Guillon and Linda Lewin. At this time, I'd like to introduce the Honorable Mayor Ed Lee, who will address the class.
Thank you, Assistant Chief Williams. Tom O'Connor, don't fret. Someone referred to me as Captain Ed Moy this morning, so. Anyway. What a great day. 116th Fire Academy class for San Francisco. 39 people who today I look across the crowd of your friends and family, and I'm very proud of the city. Proud that you've spent 16 hard weeks training yourselves and going through all of the lessons that this Academy training class has to offer to make you the best. But most importantly, you're joining a world-class fire department. And let me take the opportunity to thank Chief Hayes White and your entire command staff, the commissioners that work with you, and all the staff that we've had a privilege of working, and certainly for my 3 years as the mayor, to be there at those sites, to see, usually I'm there with the mop-up crew, but watching every detail of how the fires are fought and how lives are saved and how the emergency teams are responding as best they can to save lives. I know that I joined with Supervisor Wiener and the entire Board of Supervisors and all of our elected officials to say thank you to the San Francisco Fire Department for being a great, great partner in this city and helping all of our residents know and feel comfortable that they're in the greatest city in the world. Congratulations to the Fire Department. To this class, I'm particularly proud that as I looked over some of the resumes that you came in with, you've got very interesting backgrounds, a variety of backgrounds. Some of you were mortgage brokers, people who were a former police officer, rec and park gardener, people who had emergency backgrounds in health, or carpenters and crafts. We're going to need all of that skill. Because in addition to your firefighter duties, I always ask city employees to volunteer a lot of their time as well. But I'm also proud that the families that you have asked to join with you today, to let you know that we as a city are proud of you and that you come into a fire department that's at pretty high standards and also a city that has very high expectations, and rightfully so. We're only 49 square miles, but now our population will, in your careers, approach over 1 million people. And we're building, we're rehabbing, and we're trying to make sure everybody can live a decent life in this wonderful city. And part of that is to also say that whatever happens to people, whether they're visitors here or residents, whether they're tenants in an apartment or whether they're homeowners on the west side, that our fire department will always be there to protect them and respond in the most short minutes as possible to get to wherever the problem is. And we'll do everything we can in the city to make sure not only the response times are there, but that all the modern practices of saving lives are also inculcated and trained as I believe they were done in your 16 weeks. You're going to be joining other professionals throughout the city that also make it their lifetime goal of being the best civil servants in the city. And so you'll be matched with people that I've spent and had the privilege of spending at the Public Works Department or at the Police Department or in the Department of Emergency Management or 911 dispatchers, all of us working together to make sure the system works for everyone. Because as I said earlier, there's high expectations. But along with that, there is a deep trust that we have in our fire department. A trust that's so strong that whenever we have an opportunity to present a general obligation bond to the public to help rebuild and reinvest in our infrastructure, we ask our fire union and our fire department to take the lead in that because people trust our fire department. They know you're selfless. They know you will put your lives on the line first before others are in harm's way. And they know that you'll respond with the utmost compassion to the residents here. And with that trust, that's why next month, very soon, we ask our residents
to spend another $400 million in emergency safety earthquake response bonds, to build the infrastructure, to reinvest in our high-pressured water system. We'll also have great conversations on budgeting over portable water systems that we need on the west side to complement that. And we do this renewal every single year, not just at Lotta's Fountain, where some of you need to show up at 5 in the morning with me, but also every time there is a big event in the city, an emergency event. And of course, the 5-alarm fire in Mission Bay proved another example of how we respond and how we put that fire out well, but also lessons learned. Without that high-pressured water system and the equipment, along with the trained staff, we wouldn't be able to have saved more of the property there. And when it involves lives, that's even more important. So having that conversation with our public to deepen that trust, to make it real for them, whether it's at a neighborhood fire station or in a response to a big event, or the ongoing conversation we have with emergency management in our city and the practice training, the drills, the tabletop exercises, using Fleet Week to engage you with our military around what we do throughout the city in times of great need and events. And you know as well as I do, you're also entering into a city workforce where a major event will happen in our lifetime. It is not if, it is when. And we have to keep practicing with our neighbors, keep training them in neighborhood emergency response team, keep getting more and more of our neighbors involved in CPR and other training for the first 72 hours. We practice all of this in complement to the skill sets that you have learned and earned today. So I say this with all excitement, with knowing your backgrounds and knowing the sacrifice you and your families have made to get through this. You're entering into the best jobs in the world, the best city in the world, and I take this opportunity to thank the training classes, to thank the trainers, to thank the commission and the management and the chief, but also say thank you for joining the best fire department in the world. Congratulations to you and your family. Congratulations to the 116th class of the San Francisco Fire Department. Thank you.
At this time, I'd like to have the President of the Fire Commission come forward and address the class, President Steve McCutcheon.
Good morning, everybody. What a beautiful morning. I also wanted to make remarks in terms of the 116th class as a special identification that with the support of our mayor, Mayor Ed Lee, the creation of this particular, what I call unprecedented, exceptional, talented, special group of recruits to enter this department at this time is because of the convictions and statements of our mayor, Mayor Ed Lee. So we should thank our mayor for the results of this particular 116th class this morning. Thank you, Mayor Lee. Part of that is I can't help but have integrated emotions. It's a beautiful day. It's a happy occasion. It's a proud occasion. But for me, it's also the weekend of Mother's Day. And I can't help but drift towards my mother in the concepts of appreciation, the support she gave me, the love that she gave me, and what that mother represents to me, and many of you are out there in the audience, is exactly what you represent as well. It's the caretaking of your mother and your family in terms of what you produced in your friends or relatives of the members of the 116th class. Last night we had a fire commission meeting, and on behalf of our fire commissioner, Vice President Andrea Evans, Commissioner Francine Covington, Commissioner Michael Hardiman, Commissioner Ken Cleveland, we welcome and congratulate all of you, but we're especially proud with the command force, the training force, and with your presence this morning, Supervisor Wiener, in terms of the importance of this class, because Lord knows we need this membership. I'm always reminded at these graduations of the awesome responsibilities that we have as commissioners. It's like that system of caretaking. When there's something in need, you call a police officer. When there's a fire or accident, you call the fire department. If mom falls down, you might call the paramedic division. And all of that is part of the makeup of what we are in the San Francisco Fire Department. We're caretakers. To you members of the 116th class, thank you so much for enduring, for your fortitude, for your determination. I'm reminded again at every commission meeting when I gaze out to the audience and look upon the faces of 40 to 60 young men and women that would like to be in the same position that you are today. And the commission and the command staff would like that to happen so that we can serve this city as Mayor Lee has indicated. The greatest honor in San Francisco is to serve the public. The greatest honor in San Francisco is to serve your community and your family. Respect the badge that you're going to receive. Always respect the uniform. And from all of us, may we do a reinforcement of the convictions of the mission statement of the San Francisco Fire Department to serve the public in terms of safety as well. Thank you very much.
At this time, I'd like to welcome the Chief of Department, Chief Joanne Hayes-White, who will address the class.
Good morning and welcome to our Division of Training. We're very happy to have you here, family, friends, active and retired members, members from other departments. You're all welcome here in the Mission District where the sun always shines. Not always so out where I live, but it's a beautiful day. And today's a very proud day, a day to celebrate the accomplishments that the 116th class has achieved over the last 16 weeks. We know it has not been easy. Training is the foundation for any successful organization. You have just begun the training that you'll receive over the course of your career. And I would encourage you to make every day a training day, no matter what part of your career you find yourself in. And you wouldn't be sitting here today without the wonderful, dedicated, and committed work of the Training Division, led by Assistant Deputy Chief Ramona Williams. So I'd like to, again, acknowledge the Training Division, both here at the Division of Training at 19th and Folsom and over at TI where you were back and forth during this class. So thank you for all your hard work and dedication and sacrifice that you make away from your families to make sure these candidates are successful. Let's have a round of applause for our Division of Training. It was a proud day for me 24 years ago in April when I graduated from this very division. And I take with me every day I put the uniform on, I remember that day, and I'd ask you to do the same thing, to feel the same amount of pride that you're feeling right now throughout your career. As the mayor said and as President McCutcheon said, you're joining a very elite group of people in that we are committed to serving our community, and we're dedicated to that. And you have risen to the challenge. Again, not been easy, a rigorous curriculum, but you are here to start your career and join our family in the San Francisco Fire Department. I'm here to pledge my support and commitment to your successful careers, but ask that when you put that uniform on, you do it with pride. Always carry yourselves professionally, respectfully, and compassionately when we're serving our public, whether we are interacting with someone from the public, when we're shopping for meals, when we're at a medical call, when we're at a fire, to always remember that you're representing the San Francisco Fire Department. I'd also like to take this opportunity because we know that during the 16 weeks, it's huge sacrifices, not just for you and for our training officers, but also for the families and friends that needed to support you through a very difficult time. So that's what today is about as well. Thank you so much to all the family and friends gathered. Today is about celebration, and thank you for sharing your loved ones as they enter their career with the San Francisco Fire Department. This day also wouldn't be possible without the incredible support of Mayor Edwin Lee, who is a champion for public safety. He has restored hiring in the fire department and police department for the next several years, and we really appreciate his support. I'd also like to acknowledge from the legislative branch of government, Supervisor Scott Wiener, who is also very much an advocate for public safety here in our city. Thank you for being here today. And our 5-member Fire Commission, as President Nicasio stated, it's Stephen Nicasio, Mike Hardiman, Andrea Evans, Francie Covington, and our newest commissioner, Ken Cleveland, for their steadfastness in advocating always for a well-rounded and well-funded department. Thank you very, very much. And also from the other agencies that are here. And also a big shout out to President of Local 798, Tom O'Connor, not Jim O'Connor, although there was a Jim O'Connor that we both worked with, so that's why I think there was a little confusion. So thank you. It's all about partnership. 798 has been very much a partner in advocating also for adequate staffing in our department. So like I said, to the 116th class, stay proud, stay very committed, always give 100% when you're asked, always ask questions, continue to learn, continue to support one another. Happens that Assistant Deputy Chief Williams and I, we graduated together 24 years ago. The relationships and friendships that you formed in this class will stay with you, and they should stay with you. You go to different assignments during this first year, but please continue to reach out and support one another because, like I said, these are very, very key relationships. You'll gain a lot more over the course of your career, but very fundamental, special relationships that you've gained over the last 16 weeks. We're proud of you. We're happy for you on this day, and we look forward to hoping all of you have a very long, healthy, happy, and rewarding career. Thank you.
Thank you, Chief. Let's get something to hold this down. First, I'd like to start by thanking the family and friends that are here today to honor the 116th class and their great accomplishment over the past 16 weeks. Without your support and patience and understanding, it would have been very difficult to complete this arduous process. I know you're very proud of their accomplishments, and I ask that you continue your support throughout their phase of training as well as throughout their career. They're about to embark on another phase of their journey within the San Francisco Fire Department. And to the class, you completed 16 weeks of a very rigorous training. You've run for miles, you've tied the knots, you've raised the ladders, and you've deployed the hose. I can say that I've stood in those doorways and watched you from the beginning when it was an awkward procedure for you to follow some of the directions and complete some of the manipulatives. But I can also say with pride that I watched you grow and become more familiar and more comfortable with your actions out here on the training ground. I saw the posture of the officers when you raised that 50, how they weren't so close in support, but they actually could hang back and actually engage in a conversation and take their eyes off of your actions. I saw the growth, I saw the development, and I can say with pride that I'm happy to see all of you sitting before me today. During your assignment to the Academy, I noticed that you've also learned and grown together as a team. You've encouraged one another through various trials and victories. You've supported one another through the personal loss of a loved one, as well as celebrated the numerous births that have taken place throughout the Academy, while continuing to focus on your goals. Through it all, you have stayed the course. Your ability to work together as a team will serve you well in the field, throughout your career, and beyond. My hope is that you will hold on to your enthusiasm, tenacity, and commitment as you start your new vocation. You are now ready to move on to your first assignment as probationary firefighters and emergency medical providers for the citizens and visitors of San Francisco. But by no means have you completed your training, as you well know. The foundation was set here at the Fire Academy, and now you begin your field training to expand upon the lessons learned here. The next 12 months, you will receive training and regular evaluations by your assigned field training officers on both the engine and truck companies. You will return here to the Academy for your 6-month and 1-year final testing to complete your probation. It has been said, learning is a lifelong endeavor. That means it doesn't stop, not even after you've left the Fire Academy or have gotten off probation. Learning continues at the fire station while assisting your crew preparing meals, while checking your equipment each morning, and definitely while responding to fires and medical-related emergencies. To become successful, learning should continue throughout your career. And lastly, I'll end with this. Always remember, through it all, we'll be here at the Fire Academy as a resource to assist in the success of your career in the San Francisco Fire Department. Congratulations. At this time, I'd like to call Captain Griffey forward to speak to address the class.
Good morning, everyone. I had a lot of things to say, but it seems though everyone else has already said it, so I will not bore you with saying it again. I do want to personally thank every one of you for supporting our recruits. When they came in here, I told them that they were like our children. I don't think they believed me, but I hope they do believe that now. We nurture them and get them ready to go into the department, and I think we've done a dang good job. I do want to thank my training staff, because without them it could not have happened. They have had great integrity and determination to get it all done, never wavering, staying late, and coming in early in the morning and making sure that it happened. Taking people aside one by one if they needed to make sure it got done, and I do appreciate that. I appreciate also the in-service staff and the EMS staff for doing their part in making these people what they need to be in order to do the job that they need to do. I want to thank my chiefs for supporting us, because without their support, we would not be here. All of you. I know that you guys had a lot to do, and I have too watched it maybe a little bit closer. I got to talk to you guys when you weren't doing things as well as you had wanted to, but you got through it, and it was a wonderful thing to see. At times, some of you felt like maybe this was not what I need to be doing, but you got through that too. I want you to know that it's going to happen again, but you always remember where you came from, what you've been through. It was not easy, and it was not supposed to be easy. It is not going to always be easy. You have to remember that. Keep your head up, keep your chin up, keep your chest out. Be proud and know who you are, what you are, because we believe in you. At this time, I also want to say, because you are my children, the babies that you've just had are now my grandchildren. All right. Without further ado, I would like to introduce the class valedictorian, Anthony Soule.
Okay, we are back in open session. During the closed session, there was a motion that was passed regarding the portions of the closed session that would be disclosed to the public. The first thing we agreed to disclose related to the reason we went into closed session in the first place, which was to address probable cause reports, and that under the commission regulations, whenever we deal with a probable cause report, we are required to go into closed session. We discussed in the future trying to disclose that at the beginning and at the end, at the beginning before we go into closed session, and like we are now, after the closed session to notify the public of why we were in closed session. In addition, the executive director has an announcement.
At its special meeting of May 28, 2014, in the matter of ethics complaint number 13-131112, the Ethics Commission made a determination that there is probable cause to believe the following violations of the California Government Code as incorporated by the San Francisco Campaign and Government Conduct Code occurred, and that the respondent Alpha Bowie committed them. One violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of January 31st, 2013. 2, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of July 31st, 2013. 3, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of January 31st, 2014. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviews the entire record of the proceedings. Regulation 8B2. Each commissioner must publicly certify on the record.
Vice Chair Rennie?
Yes.
Commissioner Andrews?
Yes.
Commissioner Han?
Yes.
Commissioner Keene?
Yes.
I also so certify.
The respondents are presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing on the merits. Ethics Commission Regulations for Investigations and Enforcement 8B5. The Executive Director shall issue an accusation in accordance with the San Francisco Ethics Commission Regulations for Investigation and Enforcement Proceedings. Regulation 9A. Next announcement. At its special meeting of May 28, 2014, in the matter of ethics complaint number 14-13112, the Ethics Commission made a determination that there is probable cause to believe the following violations of the California Government Code as incorporated by the San Francisco Campaign and Governmental Conduct Code occurred, and that the respondent, Jacqueline Norman, committed them. One violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of July 31st, 2011. 2, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of January 31st, 2012. 3, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of July 31st, 2012. 4, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of January 31st, 2013. 5, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement 460 by the required deadline of July 31st, 2013. 6, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement form 460 by the required deadline of January 31st, 2014. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings. Regulation 8B2.
Vice Chair Rennie?
Yes.
Commissioner Andrews?
Yes.
Commissioner Han?
Yes.
Commissioner Keene?
Yes.
I also so certify.
The respondents are presumed to be innocent unless and until such time that allegations are proved in a subsequent hearing on the merits. Regulation 8B5. The Executive Director shall issue an accusation in accordance with the San Francisco Ethics Commission Regulations for Investigations and Enforcement Proceedings. Regulation 9A. Third and final announcement. Finding of probable cause for Ethics Commission complaint 15-131113 at its special meeting of May 28, 2014, in the matter of ethics complaint 15-131113, the Ethics Commission made a determination that there is probable cause to believe the following violations of the California Government Code as incorporated by the San Francisco Campaign and Governmental Conduct Code occurred, and that the respondent, Ted Gullickson, committed them. One violation of California Government Code, Section 84202.3, subsection A1, for failing to file a campaign statement Form 460 by the required deadline of October 31st, 2011. One violation of California Government Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2012. One violation of California Government Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of July 31st, 2012. One violation of California Government Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2013. One violation of California Government Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of July 31st, 2013. And one violation of California Government Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2014. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings, Regulation 8B2.
Vice Chair Rennie?
Yes.
Commissioner Andrews?
Yes.
Commissioner Hayon?
Yes.
Commissioner Keen?
Yes.
I also so certify.
The respondents are presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing on the merits, Regulation 8B5. The Executive Director shall issue an accusation in accordance with the San Francisco Ethics Commission regulations for investigations and enforcement proceedings, Regulation 9A.
Public comment? There's no public, so no public comment. The next item on the agenda is discussion and possible action on the minutes of the Commission's meeting of April 28th, 2014. Commissioners, any comments on the minutes? I understand that Mr. Pelpel provided some proposed corrections.
Mr. Pelpel handed me a document with markings on it, and I have not looked at it, so I would not be comfortable putting forward that, whatever changes. I haven't reviewed it.
You have it?
I have it. Would you like to see it?
Any objection to seeing or hearing his corrections?
Okay. I'm going to ignore the grammatical corrections. But on page 1, section 2, public comment, the first paragraph, the word complaint is misspelled on the last line, the first word of the last line of that paragraph. Should be complaint instead of compliant. Page 2, the first full paragraph at the top, the complainant was not present, add a semicolon after the word present. The next line of the first paragraph after recreation and park, put department. The next paragraph, top line after the word California, add the word public. On the paragraph that begins with DCA, white, third line, second word, change the word against to and.
Know about that one.
I'm sorry. Right, it should, no, forget that one, sorry.
You know, I'm not sure this is the right way to go about this. I mean, if he's not here to explain them, I'm not sure it's sufficient for him to actually hand them up. I mean, if it were one or two changes, proposed changes, then maybe, but I'm not inclined to have this be a standard practice. Any objections from the commissioners?
I would move that we adopt the minutes as presently drafted.
Second.
All in favor?
Aye.
Aye. Opposed? That motion passes 5-0. The next item on the... What?
Nothing.
Next item on the agenda is discussion of the executive director's report.
I don't have any highlights tonight other than to say that our initial budget hearing is June 16th, which I will attend. If necessary, a supplemental hearing will occur a week later. These are both Mondays.
By the way, on the previous matter, I'd like to note there was no public here, so couldn't take public comment. Okay, the executive director's report. Any comments from the commissioners? And Mr. St. Croix, on item 7, about the Form 700s. So can you remind me that the FPPC, does the FPPC have exclusive jurisdiction with respect to Form 700s?
Yes, we cannot enforce filings. We cannot enforce, in any case, misleading filings, incomplete filings. The only authority we have is to fine people for filing late.
Okay, so
any other issues are the sole province of the FPPC.
So this issue with Mr. Herrera is outside of our...
Completely outside our jurisdiction. Even if a complaint were filed with us, we would have to refer it.
Commissioner Andrews?
Mr. St. Croix, can you just remind me of the process for the Ethics Commission around budget season? Do you submit anything to the mayor's office?
Quite a bit. We had a commission discussion about this several months ago. Our budget submission this year, boiling it down to the bottom line, is we requested that we get the same budget that we had this year, including the add back that the Board of Supervisors added after the mayor's budget submission last year. Yeah. So that's our request. Ultimately, what the mayor's office does, obviously, is up to them, and then, of course, it goes to the board for. And just adding to the record, and there's also money for the campaign election, the public finance election fund, but that's statutory. That's an automatic deposit every year based on the population of the city, approximately $2 million.
Any other questions on the executive director's report? No public, so no public comment. The next item on the agenda is items for future meetings. Public comment? Nope.
I have a comment on subjects for future meetings.
Okay. Commissioner Hand.
Really a question more than anything else. I mean, there have been proposals made over the last few meetings about topics for future meetings. Do we keep track of those?
Yeah.
And if so, could we get a list of the topics that have been suggested by different commissioners at various meetings?
I think we've put them on as soon as they were suggested.
I don't
for
think
the
we have
next
any
meeting.
pending ones, but if they accumulate, then we can do that.
So we don't have an accumulation of any pending suggestions that commissioners have made?
No, not anytime recently.
And how do we treat suggestions from the public for future?
We consider them, and sometimes we put them on, and sometimes we don't.
The regulations are that the agenda is set by the chair in consultation with the executive director. So one of the things about being chair is that's your prerogative to set the agenda.
I do want to, around the lobby legislation, want to make sure that we have a discussion around.
I'm sorry, I can't hear you.
The lobby reform legislation, proposed legislation for David Chu. I want to make sure we have a discussion around on that. I know it's ultimately going to come to us at some point, but I think it's worth us finding out where they are in the process. I know there have been a few different iterations that have gone around that have had proposed exemptions to it.
I just wanted to correct you. It's not going to come here.
It's not going to come here?
Right.
No?
Because there are no amendments to CIFRO. It's just to the lobbyist ordinance portion.
Sorry. My understanding is that Chu intends to bring it for a board vote in June. I don't know if that's true or not.
I believe that's true. It just was voted out of committee on this past Thursday, so it'll be before the full board in June. I'm not sure when the first reading will be.
Jesse Menard, I believe it's June 10.
Commissioner Andrews, would you like a discussion of that placed on our next agenda?
Well, yes, I would, because I think that there were, from what its original more broad definition of what lobbying activity was compared to what ultimately it is. I think it's worth us being knowledgeable about what those changes were along the way, even if it doesn't actually come to us.
Okay. Understood. Anything else on future items? No public, so no public comment. Is there a motion to adjourn the meeting?
I move to adjourn.
Second.
All in favor? Aye. Opposed? None. That motion passes 5-0. The meeting is adjourned.
SF Gov TV, San Francisco Government Television.